bullshit.
Come on, hold on, get her, don't let her go. Come back. Good morning, are you Crystal Vogan? And Ms. Vogan was previously in court, entered a plea of guilty to theft of property, a state jail felony. That agreement was for a 4-year deferred probation with a $1,000 fine as well as restitution in the amount of $9,400. I've received the pre-sentence report. Have y'all all had an opportunity to review that report?
Yes.
And any additions or corrections or speak up, I'm
I
sorry?
just want to make sure the court knows restitution, most of the main issue we're looking at, get some of that money back.
I've got 1, 2, 3 and a quarter pages of criminal history. Well, there's a lot of stuff that wasn't dismissed. There were 14 felonies that weren't dismissed. At least 4 or 5 misdemeanors that weren't dismissed. I understand the restitution, and y'all know my position on that already this morning, but she's on probation right now in Sutton County, correct?
Yes.
I have been for 2 years.
Right. So do they know about this case? And what has happened over there, if anything? I can't understand you. When?
I was actually supposed to start in September, but I had to wait to see.
Are you really going to be able to go to nursing
Yes, I
school
am.
with this type of criminal history? Another issue that I see on here also is the restitution, because it shows $9,400, but then it also, that was from inside the bank, and then it shows $500 from an ATM and $100 from a cash app, totaling $10,000, not $9,400. Is that correct?
And that would have been added on, I don't think that's a bank fee, I believe. I don't think that.
Well, it says 500 was withdrawn from an ATM outside the bank. Is that right? You know better than anybody. So possibly the other person that was involved did that?
But if it was a withdrawal, then that would be her responsibility joint and separately, so
Right, it says, so
that's a request.
the contact from Do Good said that the defendant withdrew the entire loan amount of $10,000, 94 from inside the bank, 500 from an ATM, and 100 from a Cash App transaction. It doesn't matter if you did it or if the other person that you were with did it. Y'all were working together. So you're both, and what's the other status of the?
I don't have the other status of another person, Your Honor. That's just one that's the charge. I'm not there to put some on there. But she's responsible.
Yeah. So I mean, if there was another person and you didn't give that information, then that's, okay. Apparently the cops didn't either, so.
The facts, not to my knowledge.
And hold on. So the probations in Sutton County, have they been transferred to Harris County? So you're going in person in Harris County?
Yes, ma'am.
Okay. And so it's the state's position to go forward with the agreement?
I understand the court's concern, and the state has the same. Like I said, our initial deal was to get some of the money back on our victim. However, we understand.
So, all right, so here's what I'm going to do, Ms. Vogan. I'm going to find that you entered your plea of guilty freely and voluntarily. Can y'all hold it down over there, please? I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty. I just don't know. I just can't believe I'm even considering doing this, honestly. Can't. There's no way. It has to be straight probation, and I realize that that's going to potentially have some issues, but I can't with 14 prior felony offenses, same type of thing, so.
I don't.
You do?
No, I don't. No, I don't.
Okay. How many do you think you have?
I have 3 here and one back home.
Okay, you have lots of them that were at the same time for different offenses.
And I was never convicted, never charged.
Yeah, you did probations for them. Forgery of a financial instrument. Don't talk over me. March 3rd, 2008, Harris County, 180 days in jail, so that one was reduced. March of 2014, forging identification cards in Cuyahoga County, Ohio, 1 year probation. Same charge, same probation, so that's 2 in Ohio. March of 2014, theft, aggravated theft in Ohio, another probation, the same date, but still another charge. March of 2014, attempted drug possession, pled guilty, 1 year probation. March of 2014, same thing in Ohio, possessing criminal tools, probation, all of that. It was at the same time, but still different cases. November of 2014, forgery, 2 cases, got probations in those. I'm gonna run out of fingers. March, another one, a theft, aggravated theft in Ohio in 2014. Then we go to Sutton County, Texas, and you have 1, 2, 3, 4, 5 continuous smuggling of persons for pecuniary benefit, and that's the 10-year probation that you're on in 5 different cases.
Okay.
That's not correct.
No. Okay.
So how many cases are you on probation for in Sutton County?
It all ran together.
I understand it all.
It's one.
It doesn't run, but that's not how it works.
Yes, ma'am. Yes, ma'am.
When it runs together, it just means you're serving it at this.
Smaller.
I'm rejecting the plea agreement. I'm resetting your case for 3 weeks. We'll see you back in 3 weeks. Y'all can talk about it then. You're at, ma'am,
What?
this is not gonna help.
It doesn't matter. My life's on that.
Well, looks like you did that, not me. I'll see you in 3 weeks. Come on, hold on, get her, don't let her go. Come back.
I heard bullshit.
Everybody heard it.
You said you're bullshit.
Come back.
Sure, lawyer.
I told my lawyer he was bullshit. I didn't say this.
You don't talk like that to anybody in this case because he didn't do this either, you did.
He got me the plea.
He did get you, he did a great job. I'm gonna find at this time that your bond is not sufficient because of your attitude and because of your criminal, because of your,
I gotta go to work. So I'm gonna lose my job and everything too.
Well, maybe you shouldn't cuss at your lawyer, maybe you shouldn't have this attitude here in the courtroom. I'm going to raise your bond. What's the bond currently set at? Don't cry now after saying it's bullshit to him and acting like this in here. Stop. No, you're gonna make it worse. You're just gonna make it worse. You should, when I told you a minute ago to stop, you should have stopped when I told you to. Let's see, can you? All right, I'm going to set your bond at $25,000. Go back with the bailiff.
This hearing is a clear example of how probation violations and prior criminal history can dramatically change the direction of a case, even when a plea agreement is initially on the table. At the start, the judge is reviewing a plea deal where the defendant had already pleaded guilty to a serious theft offense involving restitution and a deferred probation sentence. The focus quickly shifts away from just the current charge and toward something much bigger: her extensive criminal history and repeated pattern of similar offenses. The judge methodically goes through multiple prior felonies across different states, emphasizing that this is not an isolated incident, but part of a long-term pattern of fraud and theft-related behavior. This context is crucial because sentencing decisions are not made in a vacuum. Courts weigh past behavior heavily when deciding whether someone can safely remain in the community on probation. A major turning point comes when the judge questions the accuracy of the restitution and the total loss amount. Even though there are discrepancies between figures like $9,400 and $10,000, the legal principle remains the same. Responsibility is not avoided by shifting blame or uncertainty about who physically took the money. In cases involving joint participation, courts often treat all participants as responsible for the full amount unless proven otherwise. This reflects how conspiracy and co-defendant liability work in criminal law. As the hearing progresses, the judge becomes increasingly concerned about credibility and compliance. When the defendant disputes parts of her criminal history, the judge responds by reading a detailed record of prior convictions and probations, reinforcing that the court is relying on official documented history, not memory or personal interpretation. This moment is important because it shows how judges verify facts during sentencing, especially when a defendant's recollection does not match the record. The emotional intensity rises when the judge ultimately rejects the plea agreement. The decision is driven not just by the current charge, but by the combination of prior offenses, repeated probation opportunities, and perceived lack of accountability. In the judge's view, continued leniency is no longer appropriate given the pattern of behavior. As a result, the plea is rejected and the case is reset, signaling that the court is moving toward a more serious sentencing posture. The final moments of the hearing show how courtroom behavior itself can directly affect outcomes. The defendant's frustration escalates, leading the judge to take immediate action by revoking the existing bond conditions and increasing bail to $25,000. This is a critical reminder that in criminal court, conduct matters as much as facts. Disrespectful or disruptive behavior can influence a judge's assessment of risk, compliance, and future court appearance reliability. Overall, this case illustrates three key realities of the criminal justice process. First, sentencing is heavily influenced by criminal history and patterns of behavior. Second, restitution and liability are treated seriously and broadly in co-offender cases. And third, courtroom demeanor can directly impact judicial decisions, including bond and custody status.